Hello, I'm John Fuller, and we're continuing our discussion about the U.S. court system, specifically our book, American Criminal Courts, Legal Process and Social Context. Today, we're going to talk about pretrial motions. This is an extremely important part of the court's process because it's during the pretrial motions that many issues are resolved and many cases are diverted out of the criminal justice system entirely. The types of things we're going to talk about today are pretrial release, motions that the defense attorney and the prosecutor may bring, confessions and admissions and the admissibility of those in court, and finally, plea bargaining, which is an extremely controversial issue. Once a person is arrested, there is a period of time that happens between the arrest and when they go to court. Most of the time, we try to let people out of jail unless they are a real danger to the community or we suspect that they may not make an appearance for their day in court. One of the mechanisms that has been developed is bail. Bail is a money bond where a person puts up money as a promise that they will return. Now, not everybody can afford bail. People don't have a lot of disposable income on hand, so the bail bond industry has been developed. The bail bond industry will post the bail for the defendant. For example, if a bail is $10,000, the bail bond industry will post that bail and charge the defendant 10% or $1,000 so that they can go free until their day in court. One of the real criticisms of the bail bond industry, the whole issue of bail, is that it favors people who have the resources to either pay the bail themselves or pay the bail bondsman 10%. One of the ways to reform the bail bond industry has been the institution of a process called release on recognizance. And so if a person has good community standing, they have a job, they live in the community, and they look like they're somebody who is not dangerous and will appear, people can be released on recognizance. Another issue that is settled during the pretrial motions has to do with the admissibility of evidence. The defense attorney will bring up motions trying to get evidence excluded from the trial so that it is not presented to the jury, and usually this is based upon some error or procedure made by law enforcement agencies. This is done out before the jury is selected, and it's a determination made by the judge based upon arguments of the defense attorney and the prosecutor. There are many types of motions that we detail in the book about the types of activities that defense attorneys and prosecutors engage in to make sure that they are able to present the best side of their case as possible. Also, the judge during pretrial motions must rule on the admissibility of confessions and admissions. And this is usually a reflection of three criteria. The first criteria is the prompt appearance rule. If a person stays in jail too long, they may make a confession simply to move the process along. And so the prompt appearance rule essentially says that a confession is not going to be admissible if the person has been in jail too long. There is a voluntariness standard, which means it has to be given voluntarily. The person cannot be abused or coerced, beaten, and have that admission be admissible in court. And finally, there is the Miranda Warnings that we've talked about in other chapters where people have to be advised of their rights. But perhaps the most important and controversial issue in pretrial motions is plea bargaining, where a person will admit guilt or at least plead no contest for a reduced sentence so that they don't feel the full brunt of the criminal law for the charge that they have. This is very controversial, but In reality, it really benefits more than just the defendant. It's easy to see where the defendant gets by with having to serve less time or be placed on probation, but also the prosecutor and the judge and the entire court system don't have to use the precious resources of the court to try the case. They can dispose of the case with a plea bargain. And finally, society benefits because not every case, even if found guilty, is going to go to prison. And so society saves money by making the process shorter and getting the people out in the dispositions they would most likely have anyway. Pretrial processes are important for the court system, again, because so many of the cases are disposed of that way, and so much of the law that is enacted really happens during the pretrial process. Thank you.